Welcome to this latest installment of our video interview series at iConnect. My name is Richard Albert, and today my guest is Sofia Ranchordás, an assistant professor of law at Tilburg Law School. But right now, she's a resident scholar at Yale Law School at the Information Society Project. And today, Sofia is joining me to talk about her new book, Constitutional Sunsets and Experimental Legislation, published by Edward Elgar. Sofia, thank you so much. I'm really excited to talk with you about your new book.
Thank you, Richard.
Sofia, let's begin. You begin your book by discussing, indeed introducing, the challenges of making laws in a time of change. And you invite us to think about how, in a rapidly evolving society, we might need what you call dynamic instruments to ensure that law keeps up with the times. What do you mean by that?
So I start my book indeed by taking a look at the current challenges faced by lawmakers. And very often, the literature actually overlooks the fact that there's too little emphasis on the gap between the evolution of society and the evolution of law. And because law, at the end of the day, is usually perceived as a very predictable and stable reality in contrast to society. So I suggest dynamic instruments, in this case, sunset clauses and experimental legislation, because both of them can keep up with time. Sunset clauses keep up with change of society because basically that they allow unnecessary laws to be terminated. Whereas with experimental legislation, you can basically try a law, see whether it works, and if it doesn't, you can just terminate it. If it does, you can actually make it permanent. But you can basically keep up with evolution of society because you can legislate quickly and incorporate all the facts that you are gathering in order to improve new laws.
And so your book discusses temporary dispositions, and I take that to mean both sunset clauses and experimental legislation. And you engage in your comparative inquiry of temporary dispositions by looking specifically at the United States, the Netherlands, and Germany. Why did you pick these three countries?
Well, it's a very good question. I could have indeed picked other countries. For example, China has a very long history of experimentation, and actually, very recently, they have been doing more research on that topic. But I decided to actually choose these three countries for practical reasons, but also for actually because they were a really good source of information for me. So the United States has a very long history of both experimentation and of the enactment of sunset clauses. In both cases, there is actually a tradition that goes back to the colonial times. There is a lot of experimentation at federal level, and in the case of sunset clauses, we see that sunset clauses are being enacted both at federal level, but also and probably actually more predominantly at state level. So there was actually a lot of information, and the literature has been, especially in the 80s and 90s, was quite focused on the analysis of sunset clauses, and to a certain extent to experiments with lawmaking. In the case of Germany, it was also like more or less the same, but only in the case of experimental legislation, because Germany also has a tradition of experimenting with laws, especially at federal level. The use of sunset clauses in Germany is more recent, and it has probably been influenced by the United States. So it started actually with the new laws on counterterrorism. However, the German Constitutional Court has delivered many decisions on the constitutionality of temporary legislation. And it was one of the reasons why I really want to study Germany, because Germany would complete my study in that sense. However, I also needed a country which was actually engaging into experimentation without having a federal structure. I could have chosen France, but France was actually too close to federal countries, because in France you actually can experiment at decentralized level in order to accommodate diversity, so more or less same argument as the United States, and you can experiment at national level. However, that doesn't happen that often. So that's why I chose the Netherlands, also for practical reasons, because I was there, so I could have access to the information more easily. But I had like two federal countries, one unitary country with less experience, but also like very eager to learn more about experimentation.
Are there any constitutional constraints or maybe rule of law principles that might constrain political actors in implementing temporary dispositions?
Well, absolutely. That's actually the main argument, main legal argument, I would say, why temporary legislation hasn't been used very often. So, for example, in Europe, different constitutional courts have been invited to analyze whether experimental legislation would violate the principle of legal certainty or the principle of equal treatment. This was actually the case of the German Constitutional Court, but also of the Portuguese Constitutional Court. And both courts actually decided that experimental legislation doesn't violate the principle of equal treatment, because there is by no means a case of discrimination because you always try to have a differentiation in order to obtain objective evidence. You're not discriminating. And of course I could just elaborate on this argument, but if you read the book, you'll find one chapter only on the topic. As far as the rule of law is concerned, and I would like to focus on the principle of legal certainty, this is like an issue which is common to both sunset clauses and experimental legislation. It actually starts out from the idea that law should be stable and predictable. This is, I would say, the traditional conception or perception of legal certainty. Nowadays, this perception has evolved. So the rule of law does not necessarily mean that we have to have laws that are stable and that are actually continuous. They should last, of course, but they should be predictable. And if you have obsolete legislation, then you don't have much certainty. So what I actually basically argue in my book is that there are actually in fact no constraints, because sunset clauses and experimental legislation, if enacted within a clear framework, confer just as much certainty as permanent legislation would.
And so what about the United States? Because we've had, as you say, a lot of experience with these kinds of temporary dispositions. What have been some of the more controversial uses of, let's say, sunset clauses or experimental legislation in the United States?
Well, with sunset clauses, there is quite famous example, and that's the U.S. Patriot Act, where numerous sunset clauses were included and also reauthorized on numerous occasions. I would say that's probably the most recent and most controversial example of the use of sunset clauses. But I would say that sunset clauses do have a bad reputation in the United States because there was a sunset boom in the 80s, and basically there were too many agencies that were flooded with sunset clauses, and at some point it was impossible to evaluate everything, which meant that many sunset clauses were only reauthorized without any evaluation. So that's probably like the reason why the use of sunset clauses remains quite controversial in the US. As far as experimental legislation is concerned, I think that the use of experiments at state level can be, in some cases, controversial. There is actually a very solid body of literature on the use of experiments and state waivers in this case in the field of social policies, and that can be, poverty, immigration, that can be detrimental to the protection of certain minorities, and that has been widely discussed in the literature, and I also refer to it in my book.
So you suggest that in the United States, temporary dispositions like sunset clauses are viewed with some suspicion. Is that also the case in the Netherlands?
Well, in the Netherlands, they are also viewed with suspicion. However, they are viewed with suspicion, perhaps for different reasons. As I mentioned previously, in Europe, in several countries, there is this very strong attachment to the principle of legal certainty. And I think that in the case of the Netherlands, that might also be the case. temporary legislation is something that people don't usually embrace because they just want law that lasts forever, even if that law will actually become obsolete very fast. At the same time, the Netherlands doesn't have much experience with temporary legislation. Traditionally, they would only enact temporary regulations in case of emergencies. But nowadays, things are changing, and the Netherlands has been experimenting in numerous fields, and I think they are being very, very innovative in their experiments. So things are changing nowadays.
Sophia, I want to ask you maybe two more questions. The second one will be about the framework that you suggest that political actors use when thinking about how and when to implement temporary dispositions. But first, before I get to that question, I want to ask you, before you give advice about your framework, do you favor use of temporary legislation, quite apart from a framework that you design that would guide political actors in implementing them? Do you think that there are good reasons why we might want to use these temporary dispositions?
I think there are very good reasons to use temporary dispositions. I don't think they are panacea. I don't think you should use them for everything. I think there are limits. But I honestly think that that these instruments are underused. So, of course, in my book, I mentioned that we should use them more often when we are confronted with rapid development. So, in innovative fields, they can be very useful because they allow regulators to keep up with the new technologies. But even like in other fields, whenever you have a different approach, whenever you want to learn from new laws and make sure that you actually constantly revise your legislation, then temporary dispositions can actually be very useful. And I honestly think that we should adopt more often this learning approach to regulation. I think things are changing both in the US and in Europe. So besides retrospective evaluation of regulations, which is something that OIRA has been striving for, I think that including more experimental regulations, or at least trying to make sure that these evaluations happen, could actually make a difference. So in that sense, yes, I would say I would definitely favor them, but I don't think they should be used in certain fields like family law. I don't think they should be included there. I mean, I think I refer to this also in the book, where actually I list a number of limits to the use of temporary dispositions.
One of the very helpful things that I drew from your book is this framework that you create to guide political actors in thinking about how and when to implement temporary dispositions. So would you say a little bit more about the framework that you've designed for more effective use of temporary dispositions?
Absolutely. Well, my framework had one main aim, or maybe two main aims. In this were to ensure that there was more transparency and more accountability in the implementation of sunset clauses and experimental legislation. This is exactly what is lacking, and it's maybe the reason why sunset clauses in particular have a bad reputation, I would say. So in my framework, I basically say, well, we should take into account the features of a certain sector. So, for example, the duration of a clause should be aligned with the evolution of a sector. So if a sector evolves very rapidly, the sunset clause might be 1 of 2 years, let's say. But if it's a sector like renewable energies, you're not going to set the sun after 2 years, right? So this is one of the things that I actually take into account in my framework. Besides that, I think it's very important to make sure that there is a very strict evaluation term and also commission, so that you'll actually ensure that these laws will be evaluated, that you actually know who and when will actually perform an assessment of the effects of legislation. And this can be done, for example, by making sure that there is a publication of the results, which is something that not always happens, but also that there is a follow-up decision on this. Follow-up decision in the sense that the body that's actually meant to decide on the destiny of the law actually publishes the decision, or at least makes it's known why a certain law is made permanent or actually is terminated. Very often you see that an experiment is more or less successful, but still the law is just terminated because there are elections and the results of the experiment just do not please the current party. So, of course, politics allows you to do this. It's obvious, but at the same time, it would be nice to at least make sure that the money spent on evaluations isn't just totally useless, and that you actually are able to get something from it.
My just went off, by the way, so I apologize.
In this case, I would actually add that transparency can be guaranteed by having publication of reports, of evaluation reports, but also by having a broader participation of stakeholders. And that's something that I also emphasize in my framework.
Well, Sofia, this has been really interesting to me to talk with you about your book. Before we go, what are you working on now?
So I'm currently working on a number of things. I'm actually finishing now a paper on where I explore, which is going to be published this year in the fall, and the paper is actually on innovation experimentalism. Actually, the title of the paper is Innovation Experimentalism: Rethinking the Visible Hand of the State. And the idea behind it is basically that when we are regulating innovation, we should take into account the timing of regulation, and one of the options here would be to actually introduce more experimental regulations, because then you can, if you have very little information about a new product or service and you have normative uncertainty about it, you can better just experiment with a new solution, new normative solution, see whether it works, and if it does, just embrace it or adapt it. So this is one of the papers I'm currently working on.
Oh, that sounds fascinating. We'll look forward to. I'll look forward to reading it, and perhaps we can talk about it sometime again in the future. Thank you so much, Sofia. Thank
you very much, Richard.
Okay. Bye-bye.
Bye, Richard. Thank you.